Okay, it's 6:30. David, I think we're good to go here. Not as expecting throngs of people tonight, so. Okay, the West Hollywood Planning Commission acknowledges that the land on which we gather and that is currently known as the City of West Hollywood is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino K'iche' peoples. This Planning Commission meeting is being live broadcast and teleconferenced on the city's website and is also provided on a wide array of streaming media platforms to offer access to the public to the fullest extent possible. You may call in to make a comment, and you may also listen to this meeting by dialing 669-900-6833. The meeting ID is 895-9175-0532, and then press the pound sign. WehoTV staff have confirmed that this Planning Commission meeting is currently streaming successfully on Spectrum Channel 10 and online at weho.org/WehoTV. In addition, and as a courtesy, this meeting is also successfully streaming on the city's YouTube channel at youtube.com/WehoTV and on Roku, Apple TV, Fire TV, and Android TV. WehoTV staff monitor this broadcast on all platforms throughout the meeting and will notify the Planning Commission secretary should broadcast disruptions arise. Please do not interrupt the live meeting by calling or texting the Planning Commissioners about difficulties viewing the meeting. Please understand that internet speeds, device reliability, third-party platform reliability, and individual or personal technical issues are out of the scope of this broadcast. If you are experiencing viewing difficulties while watching this live stream, please reload the page or visit weho.org/WehoTV to access our official live stream and to view a list of other available streaming options and a guide to troubleshoot your connection. If you do continue to experience difficulties, you can also call 323-848-3151. I'm going to go ahead and call to order this meeting of the West Hollywood Planning Commission. This is a regularly scheduled meeting. If anyone needed a reminder, it is Thursday, April 6th. It's very nice to see everyone. Pledge of Allegiance. I don't have a lot of options tonight, so I'm going to volunteer as tribute myself and lead us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Item 3 is roll call. David, can you please call roll for us?
Thank you. Good evening, Commissioners. Commissioner Meadows.
Present.
Commissioner Lombardi.
Present.
Commissioner Gregoire.
Present.
Commissioner Copeland.
Present.
Commissioner Carvalero. Vice Chair Thomas.
Here.
Chair Jones.
Here.
And we have a quorum.
Great. Item 4 is approval of the agenda. This is for this evening's agenda. Do I have any requests for changes? No? Do I have a motion?
I move approval.
Oh, great. There is a delay on the screen, by the way, so. All right, we have a motion on the floor to adopt the agenda.
And the motion passes to adopt the agenda as presented for April 6, 2023.
Great, thank you. Item 5 is approval of the minutes. 5A is a verbatim transcription of the January 19th, 2023 meeting. Are there any requests for edits or changes to the minutes? Do we have a motion to, looks like we have a motion on the floor.
Motion by Vice Chair Thomas, seconded by Commissioner Carvalero. And the motion passes unanimously, approving the minutes for January 19th, 2023 as presented.
Thank you. Item 5B is a verbatim transcription of the February 2nd meeting of this year. Do we have any requests for changes? Commissioner Copeland?
Thank you, Chair. I just wanted to mention that I will be abstaining because I was absent from that meeting. Thank you.
Great, thank you. Any other requests for changes?
My only request is you can put me in yes for the previous one as well. The delay wasn't working on the screen
Oh,
until
okay,
6.
okay. Thank you for noting that. I know it's... Okay. Do we have a motion? Looks like,
Motion by Commissioner Lombardi, seconded by Commissioner Carvalero. And the motion passes, noting 6 ayes, and Commissioner Copeland abstaining, approving the minutes for February 2nd, 2023 as presented.
thank you. Item 6 is public comment. David, do we have any speakers on the line?
Chair, we have no public speakers at this time.
Great, thank you. Item 7 is the director's report. Hello, John Kehoe.
Hello, Chair, Vice Chair, Commissioners. John Kehoe, Director of Planning and Development Services. It's great to see everybody. It's been a really long break for the Planning Commission. It's great to be back, so welcome back. Just 2 announcement of items at Council. One was at the meeting on Monday night, the Council approved a contract with Francis Cray and Associates to conduct a lighting study for the proposed billboards on Sunset Boulevard. I know there had been some concerns about lighting issues, so we've contracted with the individual firm that helped us do the first studies on the Sunset Boulevard program. So they'll be looking at all the round 1.5 and 2 to look at the potential impacts of those signs, so we can then determine if any changes need to be made or the determination of what CEQA analysis we need to do for those studies, for those projects. And then the next thing is on the next City Council meeting, April 17th, the appeal of 1317 Crescent Heights Boulevard is going to be on that agenda. So those are my updates for tonight.
Great, thank you. Any questions for John? All right, thank you very much. Item 8 is items from commissioners. Do we have anything from anyone at this time? I have to say, without those barricades, it's a lot easier to look both ways. No comments from anyone? Okay. Item 9 is consent calendar. There is none. Item 10, public hearings. We don't have any. Item 11 is new business. And the sole purpose of our meeting this evening is item 11A, which is an overview of state housing laws. I know some of us have been asking for this and are very excited about it. The City Attorney's Office will be providing an overview of recently enacted state housing laws and how these impact general law municipalities. So I will turn this over to Jennifer and Isaac Rosen. Yeah.
Is my mic on? Can you hear me?
Yeah.
Okay. All right, good evening to the commission. It's really nice to see everyone's faces. I know our director mentioned that too, but it's nice to be in person and to see everyone and get a little daylight at the tail end. So this evening, as the chair mentioned, I'll be talking about and conducting the first of what we hope is several trainings for the commission. Tonight's training is going to be an overview of state housing law, and as the chair alluded to, we'll be talking about new legislation. We'll also be talking in the first sort of half of it a bit about sort of existing state housing laws that come before us and come before the Planning Commission quite frequently as sort of a refresher. The table of contents is on the screen. I'll talk really briefly about the Planning Commission's purview under state law and our municipal code. The overarching posture and intent from the state legislature, we've seen sort of a flood of changes to existing housing laws over the last 5 or 6 years. And obviously that's quite pertinent to this body and to the actions you take regularly. We'll be talking a bit about the history of the Housing Accountability Act, the changes instituted to that longstanding law by SB 330, which amended the HAA, the Permit Streamlining Act, and codified the Housing Crisis Act. And we'll be talking a little bit about court and state guidance and how those sort of interplay and the legislative intent behind some of these recent changes. I'll talk really briefly about some of our recent ministerial legislation. As the commission knows, a lot of those items don't come to the commission for discretionary public hearings. However, you often see them in the text of zone text amendments that the Planning Commission chooses whether to recommend or not to the City Council. So they're relevant also to sort of the larger imprint the state is taking in sort of characterizing housing projects more generally or broadly within that sort of ministerial framework. And finally, I'll be talking a little bit about 2023 housing laws that impact the Planning Commission, whether it's going to be projects that will be subject to these new these new laws that come before you as discretionary hearings, or just as illustrative of sort of, again, the intent and sort of what we're seeing as a through line with the state legislature with respect to housing. An important sort of caveat off the top, obviously the Planning Commission handles quite a lot of applications, housing applications, as a quasi-judicial body. So tonight, we're not talking about any specific project. We're not talking about sort of a specific rule or interpretation of our code or state law, to the extent that's going to be pertinent to pending projects that may come before the Planning Commission in the future. But I hope this is still informative, and certainly there's a Q&A part at the end of the presentation, and the goal is to sort of refresh on some of these concepts and, again, talk about some of the new state law. One change based on what was agendized in talking with our planning director, it was originally going to include a component on the general plan and changes to the general plan that the state legislature has taken. And really, that's sort of a training in itself, so that won't be covered by tonight's presentation, which is lengthy enough as is. With that, I'm going to move forward. So really briefly, Planning Commission's purview. It's not actually mandated by state law that the Planning Commission be incorporated into.
Sorry to interrupt, but I guess I'm understanding that people watching on TV can't see the screen.
Okay, got it.
And so we're going to try to move this to a Zoom
Great.
platform, so just a moment.
All right, so we'll hold off.
Yeah, we can do a 5-minute break.
Okay.
Back in biz.
Okay. Thank you, everyone, for your patience on that. I think a remnant of our last couple of years, if it wouldn't have a technical difficulty. So thank you, everyone, for your patience. I'm going to rejoin sort of the presentation and where we were this evening via the Zoom platform. So we were talking a little bit, just really briefly, about Planning Commission's purview. So having a Planning Commission is actually not mandated under state law, but it is permitted. So if there is a Planning Commission, it's going to have certain requirements, but most jurisdictions throughout the state have a Planning Commission so that City Council can make its most fully informed decision on land use and planning issues. As I mentioned, the plan is to do a general plan housing element specific training on a later date because there's a lot of ground to cover, and the legislature has certainly done quite a bit of legislation related to housing element, especially dealing with housing equity issues. But state law, state planning and zoning law does contemplate that if an agency has a planning commission, that they have a number of things they do with respect to the general plan. And one of those that I highlighted on that slide is just also to endeavor to promote the public interest in the general plan. To the extent a jurisdiction has a planning commission, there needs to be at least 5 members, and the city by ordinance assigns the functions of the planning commission as deemed appropriate. Obviously, our planning commission derives quite a bit of its discretion from Article 19.4, that's our land use and development permit procedures. The makeup of our planning commissions under Chapter 2.52, and we also have a number of relevant policies. So I think more broadly when we're thinking about present state law, separate and apart from the new laws I'll be talking about, we're really going to be talking tonight about the Housing Accountability Act and the changes since it was enacted in the 1980s, and then SB 330. And so I think what's interesting and what we've seen from the state over the last, again, 5 or 6 years is that the Housing Accountability Act and some of these other state laws has actually had the legislative intent from Sacramento baked into the statutes, and as a result, it provides sort of a roadmap for reviewing courts when there are challenges or court cases that deal with some of these state housing laws. And so I think this quote from the state that's actually now within the actual text of the Housing Accountability Act is pertinent, and it shows up obviously in the Planning Commission's practice that California has a housing supply and affordability crisis of historic proportions. The consequences of failing to effectively and aggressively confront this crisis are hurting millions of Californians, robbing future generations of the chance to call California home, stifling economic opportunities for workers and businesses, worsening poverty and homelessness, and undermining the state's environmental and climate objectives. So language like that, in addition to language within the Housing Accountability Act that also says that the policy of the state is that the Housing Accountability Act should be interpreted and implemented in a manner to afford the fullest possible weight to the interest of and the approval and provision of housing. That sort of codified legislative intent is important, again, as I mentioned, because if there is interpretation by the courts, if they're reviewing a local decision with respect to housing, the courts are going to look at that intent. And so I've pulled a quote from a California appellate decision, California Renters Legal Advocacy and Education Fund versus City of San Mateo. It's a more recent case from 2021. So the case really does delve into the Housing Accountability Act, SB 330, some of these more recent laws. And the court said, what's written on this slide, that the intent is intentionally deferential to housing development. And they've pulled from that provision of the HAA that says when reviewing decisions of a local agency, the interpretation is to afford the fullest possible weight to the approval of housing. So we talk about the Housing Accountability Act. We also often talk in these meetings about SB 330. They're correlated in that SB 330 was a package of bills that was enacted in 2019 and took effect in 2020. It amended the Housing Accountability Act, which I mentioned before the break. It also amended the Permit Streamlining Act and added the Housing Crisis Act. So they are related in that SB 330 was the most recent set of adoptions to the HAA before this legislative session. They share the same definition of a qualifying housing development project that takes advantage of certain streamlined rights and protections. And so that definition is the first bullet point here. When we talk about HAA or SB 330 housing projects that receive certain streamlined rights and approvals, we're talking about residential units, plural only, mixed-use developments with at least 2/3 square footage devoted to residential use, and transitional or supportive housing, which are defined terms under state law. I did want to flag residential units as plural. We do have a case, a 2021 appellate court case that confirmed that the HAA and SB 330 don't in themselves apply to single-family homes. We do have a more recent state law that that does. But so when we're talking about HAA and SB 330 projects, and we're talking about these specific types of housing projects that are covered, in addition to heightened standards that deal with objective standards and standard of review that I'll discuss, these projects also receive preliminary application rights that vest. So they effectively give housing developers rights at the time they've submitted a complete application to the city's planning department. And that was a pretty big sea change that SB 330 brought about. So it means that the rules in place at the time that application were deemed complete are what applies going forward throughout the full entitlement process. And that's important because to the extent state law puts further limitations or parameters on a local agency in terms of the types of development standards that can apply, those won't be applicable to an application who already has vested rights because it was deemed complete by the local agency. And then finally, a 2017 change to the Housing Accountability Act that's part of this SB 330 package as well. The city now has an affirmative obligation when it receives a qualifying housing development project to inform that applicant within a set number of days whether or not whether the city deems that project consistent with the applicable local development standards. And that's a significant burden on local agencies, because even before the project is going to make it to the Planning Commission, staff will need to ensure that the application that is submitted is reviewed exhaustively to ensure that the applicant is informed whether or not the project, in their estimation, complies with local standards. So the Court of Appeals case I mentioned on a previous slide out of San Mateo, I think is instructive and helpful in that it really the court delves into the history of the HAA. And the purpose of this slide is just to give a sense that although it has felt certainly like a significant impact from the state legislature within the last several years in terms of how they're characterizing housing and streamlining housing projects, the HAA has been around since 1982. It's just that SB 330 and some of the recent worsening factors of the housing crisis in the state has really turbocharged some of these state legislations. And so originally in the 80s, the Housing Accountability Act still had that standard we see today, that if a project's consistent with local standards, it will be approved absent a health and safety impact. It was in 1999 that the legislature clarified we're talking about objective standards when we're looking at consistency. And then there's a couple other dates on the slide. And most importantly and most recently in 2017, there was that notice requirement I mentioned, that an applicant has to receive timely written notice from the city whether or not, in their estimation, the project complies with those applicable local standards that are relevant to the project's entitlement review. And then also in 2017, there was text added to the HAA that added what's known as a reasonable person standard on on applicability of objective standards. And I will discuss that on a subsequent slide, but the reasonable person standard is really how the legislature intends in sort of providing under the HAA the fullest weight afforded to the approval of housing. It's how the legislature intends that reviewing authorities look at that consistency finding with local standards. So also familiar to this commission, the Housing Accountability Act has a standard that's been in place for quite some time, that if a housing development project complies with objective general plan zoning and subdivision standards when that project was deemed complete, the city can only reduce the density of that housing project or deny the project if it can identify a specific adverse impact to public health and safety that cannot be mitigated. And I've included just a bullet point from how that is defined, how a specific adverse impact is defined within the HAA. I would also note that generally, courts are deferential to a local agency's interpretation of land use decisions. A city has broad police powers, certainly to set its own sort of standards that applicants must comply with. However, with respect to the HAA, there is a heightened burden of proof that requirement is on the city to demonstrate a specific adverse impact if challenged. And the courts have described that burden as based on a preponderance of evidence, which means more likely than not based on the administrative record. So elsewhere in state housing law, so outside of the HAA, but within SB 330, this is part of the Housing Crisis Act, there's also a requirement that was enacted and became effective January 1st, 2020, that says where housing is an allowable use, the city cannot impose or enforce design standards established on or after January 1st, 2020 that are not objective design standards. And the Housing Crisis Act also has a cross-reference for what that means, how an objective design standard is defined. And really it just means that everyone involved in the process, from city staff and any reviewing authority, any discretionary body, to the applicant themselves, can verify what constitutes an objective design standard outside of someone needing to utilize their subjective judgment. And the definition in terms of how the legislature defines that is attached. And so we already saw in the Housing Accountability Act and in the history of that law that the legislature amended that specific set of statutes to specify that there was a heightened standard to deny a housing project based on objective standards. That SB 330 put sort of a broader parameter on that in terms of the applicability of applying objective design standards to a project. So I mentioned, again, this California renters legal advocacy case, a Court of Appeal case, and I wanted to include language that I mentioned on that reasonable person standard. So the Court of Appeals sort of looked at that language added to our state housing laws in 2017 to sort of opine on what that means in practice. And again, the reasonable person standard, and it's quoted up here on this slide, is essentially that when there's a question of whether or not a housing project complies with applicable local standards, the reasonable person standard says if there's substantial evidence that would allow a reasonable person to conclude the housing development project or an emergency shelter is consistent, compliant, or in conformity, it will be deemed so. And when the court was evaluating that language, they reiterated that, you know, if the decision is close, it's the city that has that burden consistent with the burden placed under the HAA to show conformance with the HAA and with that reasonable person standard. And at least in this decision, the court suggested that when a standard is truly objective, there's not a ton of room for reasonable persons to differ on whether or not it sort of requires someone to make a judgment call. And I think I mentioned sort of previously with this case, I think it just shows how the courts are sort of looking intentionally deferentially at housing law. And again, that's kind of a byproduct of how the legislature has codified their intent, so it's front and center within the statutory text of these laws. So recent ministerial approvals, I mentioned at the top before we took a brief intermission. Although ministerial approvals are not items that come before the Planning Commission as projects, often state law updates these bills, and so the Planning Commission may see them in the context of a zone text amendment. To the extent the city has local discretion, it's important to both incorporate that state law and utilize that local discretion to make these bills applicable to our community as best we can. SB 9, for those, I think everyone on this commission, SB 9 was a recent law last year that requires cities to ministerially allow single-family homeowners within single-family zone parcels to do what's known as an urban lot split, in which they can subdivide that parcel into two, and also allows homeowners to, those same homeowners to ministerially create 2-unit projects within single-family residential zoning districts. Just like all the other laws we're talking about tonight, all of these are meant to alleviate or mitigate sort of the extremes of the housing crisis in the state. But these are also examples showing the push towards objective standards in other arenas of state housing law. Certainly if there's a ministerial approval, then the city would be limited in applying only objective standards because the applicant and the housing team that would have to approve the project would need to be able to cite to the same requirements associated with the project. ADU law is certainly one we see lots of changes to quite frequently, requiring a number of ordinance updates. The state continues to kind of look at accessory dwelling units and junior accessory dwelling units as an opportunity to create more density and more housing in sort of unique configurations on existing parcels with existing homes. So that's another instance where there are some discretionary ADU permits that are contemplated, but really to the extent there is an ADU that meets certain state law obligations, that requires ministerial approval over the counter with a series of objective local standards that are consistent with those state law parameters. And finally, density bonus law. I'll be talking a little bit more about density bonus because certainly in West Hollywood with our inclusionary housing ordinance, really any housing development project or most housing development projects that the Planning Commission will see is going to have the eligibility for a density bonus. because of the strong protections under our local code. So under density bonus law, the actual issuance of additional units beyond the allowable gross residential density, that's a ministerial approval that the city must provide for qualifying housing projects that have an affordable housing component. So the state has said if you're going to construct and deed restrict units for lower income folks, then under state law, that's going to preempt sort of certain local restrictions and allow you to build more units and seek concessions, incentives, and waivers. So again, because this comes up quite a bit for our commission, because of our inclusionary ordinance, I wanted to just flag that qualifying housing development projects under density bonus law are slightly different than HAA or SB 330 housing projects. To be eligible for a density bonus, there has to be at least 5 or more residential units, but that can be within a mixed-use project or condominiums or the conversion of commercial buildings to residential. And density bonus, the specific amount is based on the state law income category, so how deep that affordability restriction is on those units that are reserved for lower income folks. And then the other important piece is a qualifying density bonus project is also going to be an SB 330 HAA project, subject to those streamlined requirements and heightened standards for denial. And I think what's worth flagging is a qualifying density bonus project where if it's an HAA project and an SB 330 project, the city is restricted in the specific local standards that may apply and restricted in sort of how it conditions that project. But a qualifying density bonus project under state law means that that applicant can also seek a concession or a waiver from otherwise required local objective standards that the city could otherwise enforce. And under state law, the city has to issue, there's a set number of concessions based on the income category of those restricted units. A local agency is required to issue a certain number of concessions, provided they result in identifiable and actual cost reductions to the project that would not have a specific adverse impact to the public health or safety or otherwise contrary to state and federal law. And then separately, a qualifying density bonus project can seek an unlimited number of waivers from otherwise applicable local standards, and waivers must be granted for any development standard that would otherwise have the effect of precluding the construction of that project. There has been some, sort of similar to the HAA, density bonus law has been around for quite some time, but there's been sort of an expanded footprint in terms of how the state has thought about ways to approach the housing crisis. So density bonus law, there's been increased allowances in terms of what projects can seek out in terms of additional units beyond what would otherwise be applicable in the city. And we'll be talking about that a little bit. There has been a couple laws this legislative session that deal with density bonus. But because density bonus law has been around for some time, we also have court cases interpreting its provisions. There was a somewhat seminal case from 2011 out of the city of Berkeley. It's called Walmer versus City of Berkeley, that said, in evaluating a project's density bonus waivers, it's a broad reading of sort of what constitutes a development standard that needs to be waived in order to allow the construction of the project as is. And that case also talked a bit about waivers that a developer can lawfully request under density bonus law may be related to project amenities or certain things that make the whole project more desirable or available for it to move forward and to work for the developer. And so I think it's an important decision in just sort of looking at how these are applied in practice, sort of similar to the HAA or SB 330. They're often interpreted broadly in terms of the rights afforded the housing developer. All right. So we're moving right along. I'm going to talk a little bit about some of the applicable state housing laws that took effect or were part of this last legislative session. I would say a lot of these Lauren and I continue to sort of parse out and look at because they're brand new, and some of them, I would say, especially AB 2011 and SB 6 are quite dense, and I think we're going to see continued refinements both in how the state is thinking about these new laws and potentially additional changes going forward to the actual statutory text. But I'll be talking first about AB 2334. This is one of those new density bonus laws that sort of increase the ability of housing developers to create more units. I'll be talking about AB 1551 that sort of returned a previously sunset provision that allowed a commercial density bonus. AB 2234 is a post-entitlement permit shot clock, and I'll dig into that. AB 2011 and SB 6 I mentioned, that allows residential uses ministerially in commercial zones. And finally, AB 2097, which puts further limits on requiring parking in certain residential and commercial projects. So AB 2334, the biggest change to density bonus law from this bill was how a local agency has to measure or calculate that base density in order to provide a density bonus to a qualifying applicant. And so the definition was amended, that's the Government Code 6591506, to define the maximum allowable density or the base density as maximum number of units. So that's a dwelling units per acre standard. So if a local agency doesn't utilize dwelling units per acre in calculating applicable density, and oftentimes you would potentially see a range for density or other measures by which a local agency has calculated density on the site. For those agencies that don't utilize dwelling units per acre, it allows a qualifying applicant to submit what's known as a base density study. So the applicant would submit sort of a study based on what the actual realistic capacity on the site would be for constructing housing units where there is no dwelling units per acre standard. And the way the statutory language is written is that the local agency shall accept that base density study for calculating realistic development capacity where that standard is otherwise not codified in local law. The other provisions from AB 2334 that will impact projects going forward and ones that the Planning Commission will see. It used to be under state density bonus law that if there was an inconsistency between the permissible density in the general plan versus the zoning ordinance, the general plan prevailed, which made some sense in that the general plan is the more lofty planning document that's meant to serve as sort of the constitution of the local agency. What AB 2334 revised was to say if there's an inconsistency on maximum allowable residential density between the zoning ordinance and the general plan, whichever is larger is going to apply. So that's consistent certainly with the state's intent, again, to sort of stimulate more opportunities within existing state housing laws to construct units. Additionally, for affordable housing projects that meet specified criteria, the city is prohibited from imposing certain vehicular parking standards. Some of this is already within existing density bonus law. I know the Planning Commission has seen, and we've talked about existing provisions under the Government Code that say if you meet a certain affordability requirement in terms of your percentage in your housing project, by state law, the most housing that a local agency can require, if the applicant requests it, is a 0.5% for parking spaces per unit. And already within state density bonus law, there were also certain instances where a local agency couldn't require any vehicular parking, including if a affordable housing project was in a half mile of a major transit stop, which comes up on another bill we'll be talking about tonight. What AB 2334 also did was to add certain incentives for what's known as projects that exist within a very low vehicle traffic area. So before, there were certain incentives or concessions above what's otherwise applicable for those projects within a certain distance of a major transit stop. Now, under state density bonus law, those same concessions or increases are applicable to projects within this very low vehicle travel area. That is defined under state law. It means an urbanized area as designated by the Census Bureau, where the existing residential development generates vehicle miles traveled per capita that is below 85% of either regional vehicle miles traveled or city vehicle miles traveled per capita. So that's, to me, complicated math, but I think it's enough to say applicable to the city of West Hollywood. There's also county designated very low vehicle travel areas, and those are enumerated under state law. They do include LA County, which means we're incorporated, our city's incorporated in these additional sort of incentives to qualifying density bonus projects. So are our neighbors, Ventura, San Bernardino, Riverside, and many of the counties up in the Bay Area are subject to these new additional incentives to stimulate housing developers to create projects that have an affordability component by offering additional concessions or increases in heights that previously applied to a smaller amount of qualifying projects. So AB 1551 is another state density bonus law change. It's interesting, it actually sort of recodified what was on the books for, I believe, an 8-year cycle and previously sunset in 2021 or expired in 2021. It reinstated what's known as a commercial density bonus. So a commercial developer can partner with an affordable housing project developer and create a project either on site as part of this commercial mixed use project, or they could move forward with a fully commercial project and work with a housing developer to create affordable units off-site. And so long as they do that, they can get a density bonus where they're eligible for some of those same concessions or waivers that we see for housing projects for their commercial project. There is a little more flexibility in terms of what the city can require in those instances, because unlike housing development projects that take advantage of state density bonus law, for a commercial density bonus, it requires an agreement between that commercial developer and the affordable housing developer that's approved by the city. So there's a more active role for the city to sort of set parameters on what that agreement looks like and what those incentives are. I think what's interesting about this is in its previous iteration, before the previous bill expired, there were only 5 total units created statewide in relying on a commercial density bonus, strictly relying on a commercial density bonus. So I think the legislature is looking to sort of give it another go. And again, this is part of that broader umbrella of taking existing state laws, adding new state laws that are all meant to target the housing crisis and see what may be effective in sort of the current moment in time. So this slide just provides those kinds of eligibility for a commercial density bonus project. You can see in that first bullet point, there's in some cases a higher affordability requirement for a commercial density bonus. In terms of the percentage of units that have to be designated affordable. And again, there's a possibility under a commercial density bonus that the commercial developer can institute their project and construct density bonus units off-site, provided they're within the city and close to public amenities and close to transit. another thing that's different about a commercial density bonus is that there's sort of a non-existent list of incentives that can be granted, similar to our standard density bonus law. It's not a limited or exhaustive menu, but again, that should be thought of in the context that the city is ultimately going to approve the agreement between the commercial developer and the housing developer for what this project and sort of what that density bonus looks like. AB 2234 is an interesting one. This really is going to be handled statewide by planning departments and community development departments, but the reason it's included in tonight's training is because I think it's really illustrative of how the state is trying to address housing not getting built. So we've talked about how that's handled on the front end under the Housing Accountability Act and SB 330, which is a streamlined process with heightened standards to deny, and also sort of time limits, which are under the Permit Streamlining Act for when those projects have to be considered. What AB 2234 does is sort of addresses the issue after the project's been entitled. So the project goes through its approval process, it gets entitled. AB 2234 says that cities must now issue post-entitlement phase permits within a designated amount of time. And I wanted to note, this bill is a bit broader in terms of qualifying housing development projects than the HAA and SB 330, and that includes single-family homes. And the bill also puts certain time limits associated on city staff's review of a qualifying application that's seeking a post-entitlement phase permit. And so I'll talk through a couple of those specific instances that will slowly start to come into effect. And my understanding in talking to our city attorney is the city is in the process of updating its software for permits. So a lot of this actually dovetails nicely with sort of the accessibility measures that the city is taking to move some of this process online. But the definition here of what a post-entitlement phase permit contemplates for purposes of this new and kind of novel law, we're talking about all non-discretionary permits filed after the entitlement process has been completed, where the development is intended to be at least 2/3 residential or fully residential. When we're talking about what this means practically in terms of time limits on approval and the process, we're talking about building permits, standard offsite improvements, demolition permits, permits for minor or standard excavation and grading. Those all qualify, but it does not apply to permits otherwise covered by the Permit Streamlining Act or for fully commercial projects, certainly because they're not going to meet that 2/3 requirement for residential uses. So under AB 2234, starting January 1st of next year, city websites have to include lists. So similar to HAA and SB 330 projects, a housing developer under those laws is required to be able to access the city's website and see what specifically is going to be required for their preliminary application and their application. That process is being extended now to these post-entitlement permits. So starting next January 1st, the city has to include lists of that specific information required for a complete residential application, as well as examples of what a complete application looks like. And the state law actually calls out some of the specific types of residential projects that are listed on this slide, where those examples need to evidence to the applicant what's going to be required. So the timing restriction on this, the city will have 15 business days to determine whether a post-entitlement permit application is complete. And similar to on the front end with HAA, SB 330 projects, if that timeline isn't met, then the application is deemed complete, which is also true of the housing development project application before it's entitled. Then the city has 30 or 60 days to either approve or deny a complete application that is submitted for one of these post-entitlement phase permits. Obviously, this is a little bit unique in that the project's already been entitled and improved. So when we're talking about how the city then approves or denies an application for these permits, the way the law is structured, although it's kind of untested, and I think we'll get more guidance from the state, but the way it's structured is that the applicant, the city has to provide notice within a certain amount of days, whether they need to submit more information. The applicant can keep making revisions to the application if it's non-compliant with local standards until it's complete, until it has all the necessary information. And there are only a couple extensions beyond this 30 and 60 business day requirement. The local agency can extend these deadlines if it believes there's a specific adverse impact on the public health and safety. So the applicant and the city need more time to sort out how those permit application materials are submitted until they can be ultimately approved. If it requires outside agency review, that will be relevant for a lot of the coastal communities that need coastal commission permits, or if the applicant provides consent to extend. The other requirements, and I'll just address these super briefly. The city is also going to have an online permitting system. As I mentioned, that's sort of already in the works in the city. And the city has a compliance deadline, again, of January 2024 on that. That can be extended with certain findings. And then there's also the right to appeal. So again, this is somewhat unique in terms of how it will work because the project's already been entitled. But this law contemplates that an applicant who's submitting a post-entitlement phase permit application, if they receive word from the city within the designated time period that the city deems what they've submitted incomplete, or they deny it for failure to include the requisite information, there's a process by which that applicant can appeal, and it can either go to the city council, or if the city council so chooses, it could go to the planning commission, or both. So I'm sure there will be a zone text amendment that the planning commission will see going forward that's going to address this new law. And another component of this that I think is worth mentioning is that it has the full weight of the Housing Accountability Act behind it, in that a failure to comply is a violation of the HAA. We talked a little bit earlier about sort of what that means in terms of streamlined review and the reasonable person standard in looking at sort of compliance and how local agencies are instructed by the state legislature to review these types of applications. AB 2011 and SB 6, both bills add sort of a ministerial or quasi-ministerial right for housing developers to construct residential development in sites that are currently zoned for commercial or retail uses. And that's defined under these bills as sites where office, retail, or parking are a permitted use. So that's pretty broad. That applies to a lot of zones where housing may not otherwise be allowed. And so it allows housing applicants to build in those zones through these ministerial approval processes, even if housing is not a designated use. They're slightly different, the two bills, but they do share many of the same eligibility thresholds. We're talking about, for AB 2011, either 100% affordable or mixed income multifamily projects. SB 6 doesn't have an affordability requirement, but also contemplates a streamlined quasi-ministerial review process. So to be eligible for either of these new laws, the project needs to be within an urban area as designated by the Census Bureau. That's, I think, 90% of the state, so that's most places. The proposed site to construct housing where commercial uses are allowed has to have at least 70%, which adjoins parcels developed with existing urban uses. The adjoining parcels for a qualifying project can't be more than 1/3 industrial. It can't be on a mobile home park. There are some other environmental considerations. It can't be within a certain distance of a freeway or an oil refinery. But the purpose, again, as is the case with everything discussed tonight, is the state is looking for different ways, either with existing laws or with these two new laws, just a totally new set of standards that allow the construction of housing with limited local discretion or barriers to approval. So I mentioned AB 2011. Again, that project, to apply at some of those same eligibility thresholds I mentioned, but there has to be at least some affordability component, whether it's 100% affordable or mixed income multifamily. The affordability requirement is listed on this slide in order to qualify. Like some of our other housing laws, for AB 2011 eligible projects, only objective standards apply. And like HAA or SB 330 projects, if there are inconsistencies that the local agency believes exists with the proposed submittal for one of these projects, they have a shot clock of sorts in which they have to inform the applicant in which ways they think the project is inconsistent. And again, that's a heightened level of review here because the project could be constructing housing on a site where housing's not allowed, but there are other objective standards like setback or height that may still apply to these projects. And the reasonable person standard applies here as well. So the test in evaluating these types of projects is whether a reasonable person, based on substantial evidence, could determine the project is compliant with objective standards, save for, again, that housing doesn't have to be an allowed use on the site. What's kind of interesting about this bill, although it describes a ministerial approval process, it does contemplate that there can be a design review hearing, but it's very limited. So the city can hold a design review hearing so long as it's strictly focused on objective applicable standards, and it shall not in any way inhibit, chill, or preclude the ministerial approval of the project. So I would assume the state's trying to balance sort of the nature of a ministerial approval process with some component for the applicant and the city to work together and for people to be heard regarding the scope of the project. It also has a processing time restriction similar to the Permit Streamlining Act, and it's also worth noting that there is a phase 1 environmental review that's required for these projects. SB 6, similar eligibility I mentioned. These projects don't require an affordable housing component, but they can invoke what was until now the SB 35 streamlined ministerial approval process. SB 35 took effect in 2018. It allowed eligible projects that met a certain percentage of affordability where local agency and in local agencies where they had not met their RENA production numbers to allow a ministerial approval process. That's been open more broadly because these SB 6 projects don't require an affordability component, but they essentially get to take advantage of that SB 35 streamlined review. One component of an SB 6 project is, in order to qualify, it needs what's known as a skilled and trained workforce requirement with pretty limited exceptions. That's a public contract code requirement that basically says those that are working on the construction of this project need to have a certain percentage of workers that were participated in sort of an apprenticeship program within the building and construction trades. So there are certain workforce requirements on SB 6. And I also want to note on both this bill and AB 2011 that I just mentioned, there's also prevailing wage labor code requirements that are sometimes applicable. And then finally, I think it's worth mentioning, we're talking about housing projects on these two bills built in commercial zones. So there are some protections under state law so that if there are existing commercial tenants, the developer is going to be required to pay certain relocation benefits. And so that's just a piece of how the state's trying to think about how this is going to work in practice. And finally, AB 2097, my understanding is there will be an ordinance coming forward eventually on AB 2097. This deals with changes to parking requirements that limits a public agency from imposing or enforcing minimum car parking requirements for certain residential, commercial, or other development projects that are within that half mile of major transit stop. That definition's on this slide. It comes up in some of our existing housing laws as well, and relevant to our density bonus discussion. And there are limited exceptions by which the city can impose or enforce parking requirements otherwise prohibited under this new bill. The city has to make written findings within 30 days of a completed application that's eligible because of its proximity to a major transit stop, to say that parking really needs to be required in order for to avoid a substantially negative effect, whether that be for existing housing or special needs housing. But there are exceptions to that exception. So there are instances where affordable projects, regardless of if city determines there's going to be a substantially negative effect, are still not going to be required to have any parking. And exempt from these new requirements are required parking for EV equipment or ADA parking spaces. So thank you. I know that was a significantly long presentation, and from legal, they're not always, they can be dry, obviously. So anyways, thank you for your patience and for your attention. I really appreciate it. And we're here to answer questions that the commission may have.
I have a quick question. What does MFR stand for?
Multifamily residential.
Okay, thank you.
Yeah.
With respect to housing advocates, which of these laws, past or present or future, do they think have been or think will be effective at producing housing?
That's a good question. And I don't know that I know. I mean, I think my assumption is all of these came with some grassroots supports from different segments of people that were interested in housing. And this is all speculative, but I would assume that the state's trying sort of a series of different opportunities that to see sort of what works. I know SB 330, for instance, is supposed to sunset, I think, in 2028 or 2030. But I think the state has some of these new housing laws that have a designated amount of time, but can obviously be extended. And the purpose is, in consultation with the reports due to HCD from cities throughout the state, that the state will be able to evaluate some actual data on which of these kind of work and are worth keeping in the long term.
Any other questions? Go ahead.
I have a few, so just bear with me. Thank you so much to our acting city attorney, Isaac Rosen, and the planning staff for putting this together. You know, I think state law is a constantly evolving thing, and that's part of the reason why I thought we should have this, is to educate the public and then also to educate ourselves on new and evolving state laws, given that we have a full-time legislature and that every year these laws change. I have a couple of questions pertaining to some of the laws that we just reviewed. I'm wondering specifically on AB 2334. This is the base density study and increased incentives bill. It was mentioned that in a county designated as a very low vehicle travel area, which includes LA County, there's an allotment for unlimited maximum density. I'm wondering if you could go a little bit more into what that pertains to, what that means.
Yeah, sure. So I think we've actually seen some of that already within existing state density bonus law with respect to 100% affordable housing projects, where there's already contemplated that a project can build as big as it wants with very limited parameters on that. I think there are those limited instances under state density bonus law when you have such a extensive authorization to build sort of as much density as you want, that still allows a city to look at sort of health and safety considerations. But we've had similar restrictions on the books over the last couple years, again, for 100% affordable housing projects, and that's been more opened up. But I would say, to get to the question, I think we're looking at sort of what is feasible on the site. And I don't know that I can provide more information on that because I haven't seen it in practice yet. But I think that the intent is just to continue to open up that avenue, but the project will still have to be feasible with the actual parameters of the parcel.
Thank you. Yeah, no, I know that a lot of this is very new, uncharted territory for us in helping us reach our affordable housing and RENA goals. So just curious about that. My next question is, still on that bill, do we have a dwelling units per acre calculation that we deploy here in the city, or how does that work for us when we look at it?
We have a dwelling units per acre calculation for residentially zoned properties, and we have an FAR for commercially zoned properties, with the exception of our R1B, which has an FAR for residentially zoned properties.
Perfect. Thank you. Couple more questions. Moving on to AB 1551, commercial density bonus returns. This is talking about, basically having affordable housing as part of a commercially zoned project.
Yes.
There's a requirement for an agreement between the developer and the affordable housing developer, right?
Correct. Yes.
If we were to see that occur in the city, would we see a public notice for that kind of agreement? How would the public be made aware of that, or would it come before the commission as an informational item?
That's a good question. I don't know that that is standardized yet in state law. I think because the agreement, although it provides more flexibility to a local agency, there's not a lot of precedent for this actually being used. And to my knowledge, there's nothing actually explicit within the state law that dictates what that agreement looks like in terms of how it's noticed or considered as part of the project. I would say, depending on the scope of the project, it may be part of something that, for instance, the Planning Commission would see if it needed other entitlements as part of the larger commercial project or mixed-use project. But I think that would be contingent on the project specifically, and we don't have a ton of guidance from the state or other sort of examples we can look at for if there's a precedent or a specific way that it's handled in other jurisdictions, because it frankly just hasn't been used very often.
Got it.
Yeah.
Okay. That would be interesting to consider, is just how, if there is a ministerial approval for these types of projects as permitted by state law, how would the commission or the public be noticed of those types of ministerial actions, so that when they see a development come to fruition that may be not typical to what they've seen in past years, that they understand, these are the implications of state laws that we're seeing pass at the state level. Just bear with me, so sorry, a couple more questions. I'm totally into this, so thank you for being patient with me.
I think it's only fair, Commissioner, after everyone's sat through quite a long presentation, so please.
Thank you. So we're looking at AB 2234. This is the post-entitlement permit shot clock. There was a discussion in the presentation about time limits on city staff review for applications requesting post-entitlement permits. Could you give an example of what exactly that means? My question that I'm getting at in my mind is, does this mean that a project can take on substantive changes more than 20% post-planning commission hearing or post-city hearing? I know that has been a discussion in certain settings of the city.
I would say I don't want to speak too broadly again, because I think there's so much about that bill in particular that's novel in terms of what the legislature's intent was versus how it's going to work in practice. I would say, though, because it's a post-entitlement project, you wouldn't see substantive changes to what was approved discretionarily or as part of the public hearing process, because it's already been entitled with its set of conditions of approval and the specifics about the project. And I don't have the degree of expertise sort of that our building official probably would in terms of the specific requirements for a building permit, but I would say it's fair to say it's not going to go through significant substantive changes because it's already been entitled.
Is your question whether an amendment to an entitlement would be in that category?
Yes.
No, an amendment to an entitlement, my understanding, is still a discretionary process. It's still an entitlement.
Yes.
It's just a subsequent entitlement. This is more building permit related.
Yes.
Oh, okay.
Yeah.
Thank you so much for that clarity. Just a couple more, I promise. Moving on, we're looking at AB 2011, and I know a lot of this is still to be digested, but it's just these are thoughts that are popping up in my mind as I'm thinking about this. The bill does allow for the city to hold a design review hearing despite having ministerial approval requirements associated with the state law. I'm wondering if the city, and it's totally acceptable if we haven't gotten there yet, because this is a new state law. How do we determine, because I imagine it has to be objective, right? If we're going to do one design review requirement for one project, we would have, in this setting, we would have to do it for all of them. How do we intend to look at that? And is that a city council directive that needs to be discussed on if we're going to be allowing for design reviews on these types of projects?
Well, I don't know how it will function practically. I know we do have, the city is looking at these new laws for where there would be sort of required zoning text amendments or ones that would be beneficial to the city and where that authority vests. But I would say, just specific to the law, the design review hearings based on those objective standards. So there's already ones that would be built in, applicable to this specific project in terms of which zone it would be. But I don't know that I could answer sort of the procedural framework for sort of how a potential ordinance specific to these new projects would come to fruition. And I would also say, I think with AB 2011 and SB 6 in particular, they're pretty self-executing. So I would distinguish them maybe from some of our other ministerial approvals, like the ADU standards, where there's more of an opportunity for local standards. At least the way this bill is written, it doesn't mean that the city's precluded from crafting objective standards through its normal adoption process that would apply to these type of projects. But the way the law is written is that it's sort of what's going to be on the books at the time the project vests in terms of applicable objective standards in that commercial zone. So outside of the fact that housing doesn't have to be allowed, to the extent there are existing objective standards that apply for setback and height, those will all apply. So I know that wasn't really an answer to your question, but
It actually was.
Okay.
So thank you. I mean, what I'm hearing is that while there are ministerial elements to some of these pieces of legislation, there are still elements that need to be considered, like the setbacks and all of those things. So we're going to be, to my understanding from what you just said, we're going to be looking at how to deploy the use of these design reviews in that context, specific to those elements.
I think that's fair. Yes.
Okay, cool. Thank you. So you didn't answer my question, so thanks. I mean, I will just pause my questions for my colleagues to have some time. Thank you for doing this. Appreciate your answers, and thank you.
Anybody else have any questions? Commissioner Copeland, go ahead.
Thank you, Chair. Thank you for all of that information. It's a lot to digest.
Yes.
But just a quick question. The Housing Accountability Act says that local government cannot deny housing development projects that are consistent with local objective development standards. But then when we ran through SB 330, there was a mention that the state could still require us to waiver or concession away even some objective standards that could otherwise be enforced. Is that correct? So it seems a little bit of a contradiction. What type of objective standard would be exempt from that, if any?
Well, I think, yes, the way I would think of it is not as exemptions from our objective standards, but that those qualifying density bonus projects that can receive that ministerial approval, provided they make the findings, it's the concession that they can get from an applicable objective development or design or subdivision standard is to construct the project. So I don't know that there are categories of exemptions from applicable objective standards, but it's just to say that that law has to, SB 330 and the Housing Accountability Act have to be read with that ministerial right under density bonus law that allows a developer to say, you know, I'm consistent with these standards, but on this specific standard, I need a concession or a waiver in order to allow construction of the project. So I don't know that there are specific categories of standards that are exempt so much as the laws intersect, so that if there are a percentage of affordable units under density bonus law, there's the opportunity for the project to still be constructed with a designated concession or waiver on specific standards specific to that project.
Okay, thank you. AB 2097, as far as parking. So senior housing would be an exception probably to that, something like that could be an exception to the parking regulation. Projects would still be required to have some amount of disability accessible parking, even if it wasn't like a senior building, just your normal building. They would still have to be accessible, ADA accessible, and have a certain amount of disability accessible parking, no matter what.
Correct. And I think this is another one of the bills that I would characterize like the post-entitlement permit process, where the actual legislative text is still being processed a bit and being unwound to understand. But I can say, Commissioner, to your point, firstly, that yes, the city has the ability under the law to allow parking in instances where there's housing for elderly or persons with disabilities, and that separately, yes, there are carve-outs specifically for ADA accessibility considerations.
Okay. I see that you mentioned the HAA, and part of it has been around for quite a while, actually. It's just keeps updating itself. With any of these state blanket housing laws, has there ever been any type of exemptions or exceptions for rent-regulated cities, or reduced RENA allocations for those cities that already have high vacancy rates? Has there ever been any sort of consideration of, like, rent-regulated cities have historically been doing as much as they can to keep people housed, to keep housing as affordable as possible, but when they make these sort of blanket state laws, has there been any discussion or pendency of a bill perhaps that would exempt some of the localities from some of these?
I'm not aware of any, but I'm, as much as I feel like I know a fair amount about the housing laws, as you mentioned, because the HAA has been around a long time, that's not to say that there hasn't been discussion or consideration of those items, but it hasn't come up in my practice.
Nothing recent that you're aware of?
Correct.
The last thing, I guess, is sort of related to that, if you had heard of any pendency of any bills with regard to Costa-Hawkins again, since the last repeal was defeated, or any pending bills regarding amendments of the Ellis Act.
I have not, but I also, I try not to get overwhelmed with some of the state tracking stuff. So it's not to say that that's not percolating.
There seems to be so many housing bills going through, and so many state laws and regulations coming through. I didn't know if you knew of or were aware of anybody taking a second look at any of those things.
Yeah,
so.
I would say, I think just the tenor of the sort of larger theme is that the state is looking everywhere
Toward construction rather than.
Well, I think they're looking at existing laws. They're obviously and amending those, and then they're looking at new opportunities. And so I was particularly interested in the commercial density bonus bill, because I think that's an interesting instance where the state tried something, it expired on its own, and it's back, and maybe there's more thought of how it can be utilized in this time and the place. So I would think that advocates and legislatures are looking at everything in terms of how to make a dent in the housing crisis.
The last thing is we touched on before, we can't deny housing development project, local objective development standards, but also public health or safety impact. That's something that's come up before from the public with us, with, say, noise that cannot be mitigated or air quality. Or so the standard for that would be, could you just briefly go over that again? What would be considered enough of an impact, or who would have to make that, that decision that there's enough of an impact to that would not allow a project to go forward or to be reduced if it couldn't be mitigated?
I don't know that I have much specificity on it beyond
Okay.
I can speak to just sort of how the specific adverse impact is defined under state law. I don't know that we have sort of more within, although we do have case law certainly about the HAA and about those heightened standards. I don't know that we have
No specificity as far as numbers, if it's above this amount or this amount.
again, not to my knowledge, it's sort of in my review of the applicable law. I think we do look certainly to that language within the Housing Accountability Act that defines what a specific adverse impact is. And I have it on one of these slides. But beyond that, I would say, often that analysis is project specific, and all sort of interested parties need to look at the impacts, and that goes into all the hard work staff does in evaluating the project and bringing it forward and looking at those
That is a
impacts.
question that we often get asked from the concern from
Sure.
the public. So I don't know if that's a decision that the city makes, or if there's state guidelines, certain numbers, specificity. But as of right now, no, nothing we can refer to as far as that.
I don't know that I have sort of a clear roadmap on it. I think there's guidance certainly from the state, but I don't know that it goes into the degree of specificity and setting out the obligations of where that comes and who makes the
All right. Those are the questions I have right now, Chair. Thank you, Mr. Rosen. Appreciate it.
Thank you. Any questions on the side of the dais? No? Questions? Commissioner Thomas, go ahead. Vice Chair Thomas.
Thank you, Chair. Thank you, Isaac, for that presentation. It's very thorough, and I want to commend Best and Krieger for all the great information that was provided to us in preparation for this meeting. A lot of my questions have been answered. I had questions about the dwelling units per acre and other cities, and one of my biggest questions, though, is about objective standards. I just have some confusion around what body is determining the objective standards based on some of the timing in the documents. I wasn't sure if the objective standards, or lack thereof, was being determined by planning staff, planning commission, city council. Are these decisions made before the projects come before us? Are we making that determination? So if you can just give some clarity on that, that'd be helpful.
Sure. I think the state law, similarly to Commissioner Copeland's questions, I don't know that I have all the answers, and I do think we as much as there's guidance from the state about that process, and I can go into a little bit of what that looks like under the Housing Accountability Act, I don't know that there's a definitive answer in a vacuum outside of the specificity of the project and the specific standards that apply. I would say the way the HAA is structured, there's both that heightened standard to deny, so that's obviously applicable to the Planning Commission by the time the project reaches this body, where you're looking at a specific adverse impact and you're looking at compliance with objective standards. Separate and apart from that, there's also the obligation on the city staff team to also review the application at the time it comes in and conduct its own analysis. So I think those are separate requirements in terms of sort of the process for the Planning Commission in evaluating the project during the entitlement phase versus what staff considers at the time the shot clock starts on a complete application. But beyond that, I think it's somewhat tricky to lay out a clear roadmap of responsibilities because we're interpreting the state law specific to a specific project. So there are designated roles for different stakeholders involved with the project in terms of staff versus the elected bodies, but I don't know that, sort of similar to Commissioner Copeland's question, that we have a more heightened degree within the statutes of specificity on that.
I appreciate that answer. I'm just not sure. Sometimes when these projects come before us, we spend an hour plus talking
Yes.
about objective standards, and if it's already been determined by staff, I guess, then we're having conversations that are kind of moot. And so I'm just not sure what our purview is really and what our discretion is if it's already been determined, and what if we disagree with staff's assessment, or it's just kind of up in the air a little bit.
I think, yeah, I agree with you, and I think that that's all part of what we're trying to parse out as we interpret and assimilate these laws that are all fairly new in terms of, especially what Isaac was saying about the shot clock. That's something that's new for us, and so I think we're all trying to figure out how that's going to play out in the future in terms of our hearings.
Okay, I'm sorry, there were 2 dates on the shot clock, correct? Could you just recap those really quick?
Absolutely.
60
So
and 90 days.
sure. So let me see if I can. Oh no, I'm good. So yes, the standard for the initial review for a qualifying project in terms of consistency with all local standards for a housing development project under the HAA and SB 330, it's 30 days for projects that are 150 units or less, and it's 60 days for a project that has more than 150 units. And that's the initial step. And I think to Jennifer's point, we continue to update and interpret these state laws with additional guidance we have, but there are, at least under the HAA, that more recent component of the notice obligation on the city is read in conjunction still with the commission's discretion, although limited for these housing projects to conduct the public hearings for the necessary entitlements.
Okay. Going back to the dwelling units per acre, at the last long-range meeting, there was some discussion about moving away from FAR and moving more towards dwelling units per acre. Is that specifically for, will that be mixed use or residential, not residential, but rather when there are residential properties in commercial zones, or does that not even sound familiar to you?
No, I think that we would be looking at trying to implement dwelling units per acre standard for residential developments in commercial zones. Most of our commercial properties are mixed use, are zoned for mixed use. So that would apply, but I think that's still in development, and I don't know if anyone here wants to jump in and correct me, they're welcome to. But I believe that's the intent.
And would this body have any input on that, or would we just be told what that is going to be, the dwelling units per acre?
Any zone text amendment comes before this body for comment and recommendation before it goes to the city council for decision.
Okay, and I think I just have one other question. I had a question similar to Commissioner Copeland's about other cities, and I know that HAA, when it comes to historic preservation, I know that can impact HAA, and I know that there were some projects in the past where residents were concerned about whether or not their area could qualify for historic preservation. So could you just talk a little bit about historic preservation and HAA?
Sure. Well, the first thing to note is that these projects are still subject to CEQA. Discretionary projects under the HAA are subject to CEQA, which will come into play if there's a cultural resource on a property. We would not be able to have an exemption for that project, and so it would be extensively reviewed under CEQA. I believe there's also a component of either the HAA or the state density bonus law that restricts projects that are proposed on sites where it would require the demolition of a historic resource as well. Does that answer your question? Okay.
Sure. And my final question is, do we anticipate that we will be in compliance with the online database dashboard by the January deadline?
We currently have the ability to process things online. It's not what we want it to be, but we have been since the beginning of the pandemic taking in most applications online via email. We are working on having an updated permitting system, and that should be in place in March of 2024. So I believe the deadline was the end of 2024.
I think
So-
there are different components.
Yeah,
but
I believe we will be in compliance with that. If not, we will be very close.
Great, and I think those are all my questions for now.
And I would add just on that point too, that the sort of penalty, quote unquote, for non-compliance is just accepting applications via email. And the city is well versed in that, obviously, coming out of the last couple of years. So,
Right.
And I know our office has been working with the city team as well on getting these formulated in advance of those deadlines next year.
Great. Wasn't there an extension of 2 years
Yes.
for cities in, what was it, counties with more than 250,000 people? Is that right?
Yes, there are extensions available, and really the rationale is associated with the cost. I think for local agencies, it's not a small undertaking for cities to move this process to be totally available online, and so I think the legislature recognizes in allowing extensions or in terms of timing that it's no small undertaking to get this all completed.
Okay. Thank you. Commissioner Lombardi?
Thank you, Isaac, for the presentation, and I also appreciate all the really good questions today. I actually have a question that maybe gets into some of the questions that Vice Chair Thomas and Commissioner Matos brought up earlier. And I see that Rick Abramson, City Architect, is here now, but I do not want to put him on the spot. But this question may be pertinent to him. Dwelling unit per acre standards and AB 2334. I was just wondering, as it pertains to the acreage per unit requirement for mixed use or commercial zones that may not currently have it in our code, I would assume that there's a need or desire to update the West Hollywood Municipal Code. And I'm just wondering what that means in terms of what the density may be in those zones. And also, I guess the other question I have that may be for you, Isaac, is there opportunity to actually look at increased density for residential in those zones as that code is updated and applied?
Yeah, I think I would say, firstly, I don't know that I have all the answers on the practicalities of looking at our code relevant to future ZTAs that might change that. But I would say there's always the opportunity with a zone text amendment to look at increased density anywhere. And certainly there are, outside of what we talked about tonight, there are other state laws that allow upzoning. I think SB 10 from a couple of years ago is one bill that allows for that.
Good evening. I'll just jump in. So that the housing element that the City Council recently approved includes a lot of items for us to look at, which include looking at increasing densities throughout the cities in various different ways. So yes, that's something we'll be looking at. I think one of the things with moving over to a dwelling unit count in commercial areas, one of the main reasons we want to do that is to make it easier for us to process things through the state law density process, because right now we're having to translate our density calculations into the state law density calculations, and it's very, very complicated. And so if we can wind up having one system that works, it would be much smoother. Although our current system would actually allow for more units in commercial zones because it's an FAR and you can put as many units as you want. If we switch to a unit count, there would be a cap. So that's kind of the conundrum we're in. And I also wanted to go back to a question that Commissioner Thomas asked about the design standards. So it starts with the zoning ordinance, where we create the design standards that have to be objective. So obviously those go through the Planning Commission and the City Council that create the very objective design standards that are in the ordinance that the developers and architects are looking at, and then staff applies them. And so as as was indicated, those design standards have to be very objective, and it has to be where the ordinary person can look at it and can understand what that standard is. It's a 14-foot setback. It's not a, we don't know what the setback is. It's something that does something, but it's supposed to be an objective standard that a reasonable person could look at. So that's why it is kind of unfortunate that staff is kind of put into the situation where we have to say that it complies before something comes to the City Council or Planning Commission. But those standards, as the Urban Design Division Rick's working on, all those changes to the zoning ordinance have to meet those criteria of being objective standards, and that's where it starts.
Thank you, Mr. Kehoe. And on the dwelling unit per acre standard, you brought up an interesting point that it would actually be imposing a set limit on the number of units, which we do not have right now. So I'm very interested to see how that would move forward. And I know in the most recent RENA cycle, we have sites that are designated, probably quite a few in commercial zones, and I'm wondering if maybe some of those sites could be identified and there could be some potential hypothetical modeling study to understand structure and massing and how many units might fit in to those zones. And it seems to some extent like we haven't seen as much housing in those commercial or mixed-use corridors as maybe could potentially be there. So I'm just wondering if there's opportunity with all of this and a chance to revisit it as well. And that is probably a good segue to another question I have here, which is relating to the Assembly Bill 2011 and SB3. You had noted, Isaac, ministerial approval for certain multifamily housing developments with affordable components. And then you had said if they're new or CEQA exempt. And what I was wondering is, what if there were an urban infill type project that were going to residential from commercial? Do those laws apply or not? Is it only new?
I don't.
What's new?
Yeah, I would say that would have to be a project specific determination, and I don't know that I have the expertise to answer that specifically.
Okay, I don't know if it would be tied to the percentage of renovation. I know that that's a trigger that usually relates to codes. So would it thereby be considered new if it were over a certain percentage of redevelopment? I realize that's a difficult question, but that's one thing I'm just thinking about. I don't know of the likelihood that we would see a project like that, but if we were to, it'd be interesting to know if it applies.
And I think that is one of those in a category that's probably a follow-up, just as we kind of dig into the specifics of how CEQA will intersect with some of these ministerial housing projects that are unique in terms of where they are and what the environmental considerations are.
Okay,
Yeah.
Thank you. And then, one other question. I think Vice Chair Thomas just brought this up too, but on the city website, in terms of Assembly Bill 2234 and the entitlement process and what's posted on the website, I know lately there's been a lot of confusion about things like landscape plans and what the requirements are. So I assume this is a great opportunity to just, make things as clear as can be, which I'm sure you all are going to do. But you're looking toward making updates in terms of that process?
So one of the things we're going to be doing pretty soon is establishing a developers library on our website, which will list or have links to all the different provisions that the city has, our climate action plan, our housing plan, all of our documents. It'll include links to outside agency requirements, because we want to create a place where a developer or a homeowner who wants to find out what developers have to do can go to that page, and that there would be links to all the different forms and documents that they would need. Hopefully it will be up pretty soon, but I think that's a really important way to start getting to what you're talking about, to where people know exactly what they need to do.
Okay, great, thank you. And then I have one, hopefully really easy question. Assembly Bill 2234, the entitlement permit shot clock. I also had a question similar to Vice Chair Thomas. I missed one thing in the notes that related to the approval to approve or deny a complete application. It was 30 days for 25 or fewer units and 60 days for something else, but I didn't get it.
That's good recall too. So thank you for, yes, that's correct. That's absolutely correct. It's a little, I know this has been the common thread of what I've said, but this is one of the ones where it's a little ambiguous in state law, again, because these are entitled projects, and there's a 15 business day requirement to tell the applicant of a post-entitlement permit whether that application is complete. But Commissioner Lombardi, you got it absolutely correct. It's 30 days after a complete application, after an application is deemed complete, to either approve or deny if there's 25 or fewer units, and it's 60 days if there's more than 25 units. And that important other component of this is that the process keeps going, so that if the city does find noncompliance or requires revision, that clock starts over, and the applicant works to do a complete new submittal within those same timeframes.
Okay, great, thank you. So that was more than 25 for 60 days.
And I'll explain a little bit more on how it currently works. So right now, this law is mostly going to apply to building permits. That's really the key category. And so the city of West Hollywood already does this. The formula they're talking about, we already have that kind of a process where someone applies within a certain number of days. We provide a letter back to them that says, here are the items that you need to address or correct on your building set of plans. And that goes, and we have different tiers based on the size of the building, and that can go over multiple rounds of plan check. So this law is going to force us to kind of modify that process to go into this system, which is much more hard-edged, I would say, because we're going to be having to reject things. Right now, we just tell people, here's a list of things you need to correct. Now we're going to have to say we're rejecting things. So it's going to be a little bit harsher sounding for people, but that's something we'll have to comply with. But we already have a process where we provide letters to people in a certain amount of time, and we go through a cycle, and we'll be continuing to do that.
Okay, thank you. And I have one last question that may be a little bit more challenging to answer, but one thing that has come up a lot in our review of projects here is how the question of when a project is deemed complete, or how we define a project as complete. And I'll just say, in my professional experience working on the design side, I've worked on many projects where there has been an intentional locking in of a current code or standard, and then sticking with that through the duration of the project. Usually that's been driven by the fact that there may be more cost associated with updates to codes or updates to standards, and in particular with sustainability, controls, and all of these other things. What's interesting to observe here on the Planning Commission is that, and through City Council, is that we've seen projects that have actually sort of taken in the new code or parts of it, or tried to take in new standards and kind of redefine the projects as they move forward, including just this week with one project that was at City Council on appeal. And I'm just wondering, how do we work through these things? What does it mean? Because I'm not used to seeing projects kind of change those measurements as they move forward. And is there an opportunity to provide any clarification within our code in terms of what is updatable, and maybe some of it relates to housing accountability, and at what measures it can be updated, and where it's too late?
Well, I would just say, I think we need to be conscientious again that we, the purpose and the agendized discussion tonight, we're talking really broadly about the laws, so I want to be cognizant that we don't sort of discuss items that are part of pending projects that are in various stages. And I think part of that is also, and apologies in advance because it won't be a very robust answer, but I think part of that is, to the extent we're looking at specific rules, a part of these laws or interpretations that may be relevant to pending projects that will be sort of project specific and come up as part of a notice public hearing.
Okay. And I understand I wasn't expecting a really easy or clear response to any of that. And it kind of goes back to when a project moves forward, or if it were to be appealed, for example, or if housing acts change, what does that mean? Does it go to planning commission? Does it go to the city council? What can they change and when? Is there a date by which it's locked in?
So the zoning ordinance has a section that locks in the rules at the time that it was applied for, that we can't enforce new rules on them. It's a restraint on our action as a city.
But it's only on our side, though.
So it's our side.
Okay.
But they can voluntarily, if new rules come into play, they can voluntarily use those.
Understood. Okay.
And
you.
it, again, I think part of it is those, often we're looking at that in the context of a very fact-specific analysis with the specific project, the deemed complete date, the specific standards. So I do want to ensure we avoid that as part of the sort of purpose of tonight's.
Real quick though, Isaac, maybe without talking about in more detail our own zoning code and really keeping it to the agendized discussion of state laws, can you talk a little bit about when and how various state laws apply to a project?
Yeah, I would say to the extent, and this was touched on a little bit by John, but to the extent an application is submitted and deemed complete under SB 330, that locks in the local standards. That doesn't preclude an applicant from seeking to take advantage of state laws that come into effect after that vested right in local standards. And so it's challenging often because we're playing catch up often with changes to the state law that are fast moving. And I think I touched on this in one of our more recent state laws, which is that you could have an instance where those standards are vested in place, and then the state may make further parameters or further box in a local agency on specific standards. And it's always going to be a challenge, and I think it's going to be contingent on the specifics, certainly of the code in place at the time locally versus the state laws that have taken effect since that time.
Okay, thank you. I appreciate that. It was the question that I didn't want to ask, but also wanted to ask, so thank you.
Commissioner Matos, do you have additional questions?
Just one, I promise. Okay, so just looking at AB 2097, this is, dictating that there's no parking requirements that could be put into new projects, residential, commercial, whatever. I do want to ask if we're considering, and if the answer is, it's the new state law, that's totally fine. But are we considering, given that the city can require EV or ADA spaces, are we considering looking at an objective standard requirement that we can employ on projects moving forward with an EV or ADA compliant? And I just ask that because, this city is one that, prioritizes helping those that are differently abled or have mobility challenges. So I'm wondering how we would look at that as a city going into this new law.
I think we're still developing the recommendations, and we'll bring that back for a public hearing that's been agendized to have a better discussion about that. So
Okay, perfect. That's my last question.
Awesome. All great questions. And again, precludes me from having to ask many of my own. Okay, unless anybody else has any questions, we will move on to our next item. Isaac, thank you again.
Chair, we do have a public speaker.
I know, but that's not until after items 12, 13, 14, and 15.
No, he would actually like to speak
Oh,
on
you mean
this
on the
item.
actual item?
Yes, on this item.
I'm sorry, that's my apology. Please go ahead.
Thank you. We have no public speakers in chambers. I'll turn it over to Joe for the Zoom.
Yes. Will the speaker, James, please state his name and city of residence? And please remember to press *6 to unmute.
Hello? Hi there. I'm sorry I almost got skipped over. I mean, there's a lot of long-windedness, and this is what happened. So I appreciate someone saying that. So, Chair, just be aware of it. Because I already had all the audio technical difficulties where I couldn't call in and listen for the last hour. So it's very frustrating. Besides that point, I just want to make the fact that I've lived in the city for 12 years. I have literally had to deal with getting on lists for the city of West Hollywood for the last 10 years with no avail. There is housing crisis going on within the state. The state has to interject and set a mandate. And as John Keogh had explicitly said, and that the commission is understanding, and I appreciate you having this hearing session, I almost missed it if I didn't go to the city website. So it's frustrating because we are at a moot or a quagmire where you have no available housing. We're relying on West Hollywood Community Housing Corporation. That's the only developer. People are adamant they don't want it in their neighborhoods on the west side. There is no affordable housing with half this city and the affluent neighborhoods. I would have to wait 20 years of residing in this city in order to move west, in order for me to be in a nice area without having to live in a commercial zone. I mean, it's ridiculous. The state said to the city of West Hollywood, you need to build 3,000 units because of what didn't occur the last 20 or 30 years. Then you have developers who are only interested in developing hotels and luxury apartments and condominiums, and then go under the radar and devise a plan to rent Airbnb, which the city wasn't even aware of it. And then they wanted to bring the city to court. This is ridiculous. The city hasn't got a grasp of it. And now the planners are in crisis mode, literally, trying to have an urgency about them how to approve things. Because the state says, since these cities are incapable of implementing their own housing program, we have to then intercede. I mean, me being a local, I would have to wait for someone to die off or someone to be into assisted living in order for me to qualify for a unit, which I am. I'm the youngest person in a disabled unit. That's the only reason why I'm still in West Hollywood. Because the landlords, when you're in a rent control, are finding loopholes to get you out. Because they don't want Section 8. They don't want affordable housing programs. And so the state and the city has to protect us against slumlords or people who are trying to devise a plan to sell off the property or a way to turn it into Airbnb. I mean, it's ridiculous. We're in 2023. The housing element says until 2029. There is no way the city can accomplish that goal. I mean, I'm just being honest. There is no warehouses. You would have to basically take all the hotel rooms on Sunset Boulevard and partially off of Robertson in order to maybe achieve half of that. Thank you very much for your time.
Thank you, and thank you for the reminder, David. I'm sorry, we don't always have speakers on new business items, but I do appreciate the reminder. Thank you.
Thank you, and that was our last speaker.
Thank you. Item 12 is unfinished business. There is none. Item 13 is excluded consent calendar. There is none. Item 14 is items from staff. Item A is planning manager's update.
Good evening again. I will update you on what is coming up next on our agendas. Tonight is April 6th. The next meeting is April 20th. At this moment, it looks like we will have one billboard at 9201 Sunset Boulevard and one subdivision map hearing. And then on May 4th, we're currently expecting to have 2 zone text amendments, one for multifamily parking standards, excuse me, and one for shared housing, micro units, and senior congregate care. Upcoming on the subcommittees, excuse me. Design Review Subcommittee currently does not have anything upcoming. Sunset Arts and Advertising likewise does not have anything upcoming. And on April 20th, for the Long Range Planning Project Subcommittee, we will be discussing tree canopy standards. And then I just wanted to note, because the Director Kehoe inadvertently left it out, that on Monday night as well at council, they heard the appeal for 8500 Santa Monica. The appeal was denied, the project was approved, and so that moves on. And if you have any questions for me, I'm here to answer them.
Thank you. Go ahead, Rogerio.
Jennifer, I saw on on 8850's Sunset's website that they've updated all the renders, and it looks like they've responded to a lot of the comments that Design Review made. Is that anywhere on the agenda? Are we going to be seeing that project anytime soon?
Not quite yet. There's still some work that needs to be done on that project before we bring it forward to another public meeting.
Will it come to design, will it go to design review? Or
I'm not sure at this point whether it will or won't.
Okay, great, thank you.
Any other questions for Jennifer? No? Okay, I don't know why it says A and C, there is no B, but I'm just going to go with it. Okay, item 15 is public comment. David, do we have any public speakers?
No public speakers, Chair.
Great, thank you. Item 16 is items from commissioners. Any items from commissioners?
Really quickly, Chair.
Go ahead.
Thank you so much. I really just wanted to take a minute to thank the planning team here at the City of West Hollywood and our acting city attorney, specifically Isaac Rosen and Jennifer Alkire and John Kehoe, for helping us through this, overview of new state laws. I think it's extraordinarily valuable for whoever's sitting up here now and in the future to be able to review these laws, and additionally members of the public, making sure that everyone has full information as it comes available, so that they understand as we make these decisions, that what is guiding us to make them, what is compelling us to make these decisions in a certain way. I do, for whatever it's worth, think that we should consider looking at this as a body on a rolling basis. Maybe it's once a year, every April, where we're doing a quick review of any new state housing laws or applicable planning development laws that did become enacted in the January prior. That there is this constant flow of information out to the community, but also to the folks up here. But thank you again for taking this time. I think it was exceptionally valuable. It was well presented, and thanks for answering all our questions.
Anyone else? Go ahead. Oh, did you want?
Okay, well, thank
You
you,
always-
Chair.
you always
I will-
trick me that
No,
way.
I was just looking at you, but thank you. I'll take the opportunity anyway. I'd like to echo what Commissioner Matos has stated. Thank you so much for taking the time to prepare this and to give us this presentation, answer our questions, and hopefully help all of us navigate all these changes a little bit better, a little easier. And I would also like to wish everyone happy Easter that celebrates, happy and peaceful Passover, Ramadan, and belated happy Nowruz to those who celebrate any of those. And that's it for me tonight, Chair. Thanks for asking.
Thank you. You always have that sneaky look on your face, so I have to make sure. I mean that in the nicest way, by the way. Anyone else? Commissioner Thomas? Vice Chair Thomas? Sorry. I will get it right someday.
I have a quick question for Mr. Kehoe, if he could come to the podium, please. So about 2 years ago, when we saw the first billboard from the Sunset Arts and Advertising Program, I had a question about the Cray study and what if the study was flawed and we had all these billboards that was just far too bright for our residents. And now we're doing a study about the impact of the billboards, but it's by the same agency that did the original light study. And so since that agency has a vested interest in saying that there's not a whole lot of impact, I'm just wondering, and the decision's already been made, but I was just wondering why, for the sake of, transparency or whatever, that we didn't consider, or another agency wasn't considered when looking at the impact of the billboards. I just wanted to know if you could maybe speak on that.
I don't remember us saying that the lighting study was flawed.
No. I was saying, what if 2 years ago I had a question of what if the lighting study is in some way is in some way flawed and the billboards end up being far too bright and the impact on the residents is substantial. How would we respond to that? That was a big question I had at that particular meeting. I'm not saying that it is flawed. I'm just saying that now that we're looking at the impact of the billboards and the light and all of that, I'm just wondering why we didn't consider, or if you have any input as to why another agency wasn't considered, and we would, because the agency that did the light study would have a vested interest in saying that there's not a huge impact, I would think.
So we're looking at the future projects that are in the pipeline, and we're taking into consideration the existing lighting and seeing what's changing, because the existing lighting study only looked at those in round 1. So we now have a round 1.5 and a round 2.0, and so that's more signs and more lights. So we're wanting to see if there are any issues that need to be looked at with these additional signs. So we want to go to the expert, and Francis Cray is one of the experts in lighting of this type. And of course, they did do the original study, so they have all the information. And so it's the easiest for us to go with them, and that's because they are the experts in that subject matter.
Okay. That was it.
Oh, here we go. Now it works. Anybody else? Go ahead.
I wasn't actually going to have any comments, but actually, since Vice Chair brought it up, just a couple of quick notes that maybe relate to the lighting study as well, since it seems topical and was just heard at City Council. I'll just start with saying, in the original report that Francis Cray Associates produced, well, so during the City Council meeting, I know that there was a comment from Francis Cray that there were light studies or observations that were made or recorded that suggested that Sunset Strip is within the light levels of an LZ4 category. And I don't recall seeing that documentation in the report. Not to say that it doesn't exist, but it would have been good if that were included. So I'll read up myself as well. But it was an interesting statement that he made because I hadn't heard that before. Either way, though, I think just for some perspective, the challenge that maybe needs to be considered as this study moves forward, and I'm sure that Francis Cray and Associates will look at this as it may be that LZ4 light levels are observed on the Sunset Strip, and so we're designing to LZ4 standards, but the real question and what the study will hopefully reveal is the intensification, the use of electronic billboards, not just static billboards, and the quantity of them, and that intensification and what that means. LZ4 probably does make sense as the right category. So the intensification is more the question. But also I would say, I recall in his original report that there may have been some notes about buildings that were located, or billboards that were located within 200 or 250 feet, something like that, within residential properties. And there may have been some guidelines there. Francis Cray did make some comments about LZ3 light level standards at residential properties. So it may be worth, as this moves forward, taking a look at how we put this all into the sunset billboard policy, and if there needs to be something amended to those specific sites. Whatever we can do to help, mitigate areas of concern. And then also with the intensification, these standards were built around a certain billboard size. We're seeing billboards that are larger. Fortunately, a lot of those are getting studies so that we see what that means and can at least have a documentation and evaluation of it. Beyond that, though, I will say, Francis Cray is definitely one of the most distinguished engineers and designers in the industry, and so it's probably really good that we have him for consistency, and he's well equipped to serve in that role. So I just wanted to make that note. Full disclosure, he went to Penn State, so did I, but he's great. So I think it's the right person to be doing the work. So that's not my concern, but I do hope that there's an awareness from city staff, and I believe there is, and from Francis Cray and Associates as well, to think about what this intensification means. So, thank you.
Great, thank you. Unless anybody else has any comments, I was just going to, again, thank you, Isaac, for the presentation, and for staff. It's not the first time that we've done this, and I hope it won't be the last, but it was really helpful, and there have just been such a deluge, kind of a fire hose of laws coming down, that I think it is hard to know what supersedes and transplants what, and that was really helpful. I took a lot of notes, and the reading that you sent through was really helpful as well, so thank you for that. Unless anybody has anything else, I'm going to go ahead and adjourn this meeting. We will adjourn to a regularly scheduled meeting on Thursday, April 20th at 6:30 p.m. here in person. Thanks again, everyone. Have a good evening.